What I want to do in this lesson is talk about the termination of a leasehold agreement, of leases specifically. Now, this is going to be a two-lesson encompassed set of videos because we're going to focus on the first few major methods by which you can terminate a lease in this lesson. And then in the next lesson, we'll talk about the final major method, which is, of course, the method of forfeiture, which is a little bit more legally and logistically complicated, and hence why it deserves its own separate lesson. This is actually, in fact, the penultimate lesson on the subject of leases. We're going to spend some time looking at the process of bringing a lease to an end, of terminating a lease. There are a number of ways in which one can terminate a lease. We'll discuss, like I said, the majority of those in this lesson, and then look at a separate issue, the issue of forfeiture, in the last lesson on this subject. So, the termination of leases can be achieved in one of 6 different ways. You have expiry, you have notice, you have surrender, you have merger, you have repudiatory breach, and then finally you have forfeiture. We're going to deal with expiry all the way down to repudiatory breach in this lesson, and then, like I said, one more time for the record, the next lesson is going to cover the issue of forfeiture. For the most part, these are very straightforward, hence why they're not getting their own separate lesson, because they're not that difficult to understand. So we can really just run through all of these really quickly in this lesson, and then the most complicated one we'll deal with in the last. Expiry. This is the most simple formulation for the termination of the lease. A fixed-term lease will provide a start date as well as a duration period in which the lease is active. Once this period has elapsed, that time will expire and the lease will come to an end. There can be a situation where the tenant remains in the property and the landlord agrees to a new agreement, and the point at which the point before that happens, before a new agreement is made, obviously the tenant becomes a tenancy at sufferance, something that we looked at in the previous lesson. But then when they get a new agreement in place, then this turns back into an ordinary leasehold agreement. As I mentioned, multiple different points throughout this series of lessons. Essentially, a landlord or a letting agent doesn't really want to have their tenants just leaving. It would probably be more beneficial for them to have the tenants stay in the property for as long as possible, so long as obviously they're a good tenant and they don't make any noise, or they're not they keep up to date with the rent. So as long as that happens, for the most part, there will be the option for the tenants to agree with the landlord or the letting agent to an extension of a lease, or maybe a new lease agreement, which essentially just allows them to extend the period in which they live there. This is obviously something that takes place in lots of circumstances. In fact, as a little side note, this is something that is going to have to be dealt with by me and my partner this month. So another example of how this all operates. Another method by which a lease can come to an end is through a notice to quit. In some circumstances, the tenant of the property may decide that they want to terminate their leasehold agreement before the expiry date in a fixed term leasehold agreement. If there is a provision within the agreement which allows for the termination of a lease at an earlier time, for the most part and in almost every circumstance this is actually available, owing to the fact that you don't want to necessarily lock your tenants into an agreement of over a year and cause quite a lot of problematic issues when it comes to if they want to quit the tenancy agreement. It may even also be statutory required to allow for the notice to quit. I'm not too sure. However, specifically, if there is a provision in this agreement, it will allow the tenant to release from their obligations with a notice to quit. The third method by which you can terminate a lease is through surrender. This is where there is an agreement between the landlord and the tenant that the tenant is going to give up their rights under the leasehold agreement. This essentially terminates the lease by way of an agreement. They're able to just essentially both come to the conclusion that they want to end the leasehold agreement. So it's a little bit like a notice to quit, but it's a notice to quit that is agreed upon by both parties, by both the owner, the freehold owner, and the leasehold owner, the landlord and the tenant. The idea of repudiatory breach is one in which there is a breach of obligations not on the part of the tenant, which is something that we will deal with when we look at forfeiture, but instead a breach of an obligation on the part of the landlord. In such circumstances, the tenant may be in their right to accept the breach and terminate the lease. This is obviously something that can take place, and one such example of how this is has been established in case law is from a case in 1992 of Hussein and Melchman. In this case, the landlord had an obligation under statute to make repairs to the property that they owned, and this was something, in fact, which they refused to do. The tenants argued that the repudiatory breach was accepted on the basis that this terminated the lease. Their failure to uphold their statutory obligations led to a repudiatory breach, and that the tenants wanted to accept this, which would then lead to a termination of the lease. Fundamentally, the question for the court was whether or not the claimants, the tenants in this case, were entitled to terminate the lease on the basis of this repudiatory breach. As you would probably expect, the court held that this breach was repudiatory, and as such there was the ability for them to terminate the leasehold agreement. This is something that is also affirmed, I'm not going to say reaffirmed because it's an earlier case, but it is affirmed in the case of National Carriers Limited and Panalpina Limited from 1981. This is where there was a leasehold agreement, and essentially it was held that the agreement can be frustrated like any other kind of contractual agreement. For those who want to know more about that, go and have a look at our lessons on contract law for looking at the nature of frustration. Finally, then, we have the idea of merger. Merger is probably the best way of ending a lease agreement if you are a tenant, and this is essentially where the tenant obtains the freehold estate, at which point the lease will merge with that of the freehold, and they will become the full owner of the estate, and there would be no need for a lease to exist. So if me and my partner decide that we wanted to purchase the property that we live in right now, that we rent in right now, then there would be no need for us to actually have a leasehold agreement with the landlord, because we would effectively become the landlords, and we would therefore have merged the freehold and the leasehold estates together, at which point we would just have an ordinary freehold estate. So, like I said, best way for a tenant if they so choose to purchase the property, because then they just become the full owners of that property. Like I said at the start of this lesson, we will go into the concept of forfeiture in the next video, and this covers some of the circumstances in which a tenant may fail to fulfill an obligation, which can then lead to the termination of an agreement and an eviction from the property. This lesson is going to concern itself with the issue of forfeiture when it comes to the termination of a leasehold agreement. We focused on all of the other different ways and methods by which you can terminate a lease agreement in the previous lesson, including things like merger, repudiatory breach, the notice to quit, termination, at least the an end of a leasehold agreement, the end of an agreement whereby the duration has elapsed, all these different kinds of things. But forfeiture was one that I said was legally and logistically a little bit more complicated, and so really merits its own video in and of itself. Now, this is actually our final lesson on the subject of leases, and we are going to spend some time, like I said, talking about this concept of forfeiture. So let's just begin with asking the very simple question, what is forfeiture? Forfeiture is a remedy that is available to a landlord for the breach of a covenant in a leasehold agreement by a tenant. Simple as that, really. It will lead to the termination of the lease, and often it will also lead to the eviction of the tenants from the property for which they had previously been renting from. There are a number of steps which are required for a landlord before they are able to instigate the process of forfeiture. So they can't just press a big button, the forfeiture button, and then the high court enforcement agents then come along and evict the person in question. Instead, there are steps and stages that they should go through, and there are also remedies from forfeiture that a tenant can actually go about to try and essentially allow for them to either stay in the property or to get some kind of financial compensation for their eviction. It also concerns the type of covenant that is breached. So there are really two different types of covenant for which there are two different procedures of forfeiture. The first is for the non-payment of rent. That is the first type of covenant, and is one that is almost universal for every and any single type of leasehold agreement. Almost every single lease or renting situation will involve the payment of rent. Simple as that, really. The second type of covenant that can be breached is any other covenant. So the courts and the law delineates the idea of non-payment of rent separate to that of any other kind of covenant and any other kind of agreement. Couple of points of note to begin with then. So the landlord can waive their right to forfeiture in certain circumstances, which means that if they in the future decide to come and try and instigate a process of forfeiture, they will fail in that goal. If they have knowledge of the breach, for example, but they do some act which recognizes the continuation of the lease, this will cause them to have waived their rights to forfeiture or for a particular breach, because it essentially implies that the breach in question was not severe enough to warrant the termination of the lease, at least in the eyes and the intent of the landlord. So if they knew about the breach of the covenant, but they then recognized the continuation of the leasehold agreement, then they waive their right to forfeiture. Because theoretically, what the point of forfeiture is as soon as a breach of a covenant for which merits forfeiture takes place, the leasehold has been terminated. So if they know about a breach of a covenant and they recognise that the lease still exists and it still continues to exist, then that therefore represents a lack of termination of forfeiture. If the lease in question is a residential property and is being used specifically for residential purposes, then the landlord has to go through the process of the Protection from Eviction Act of 1977. This will involve getting a court order for eviction in accordance with Section 2 of that legislation. Specifically then, when we think about forfeiture for non-payment of rent, this is the most common type of forfeiture which takes place, given the fact that it is the most consistent type of covenant that exists within any kind of leasehold agreement for which there can be a forfeiture and a termination of the leasehold agreement, and so as a result of which the non-payment of rent is the most common type. The first demand and the first requirement is the formal demand of rent on the day that it is due. If this is not satisfied, then there is the opportunity for forfeiture. The landlord must then acquire a court order if the property is commercial. Simple as that, really. When it comes to other kinds of breaches, other kinds of covenants, if there is a desire for forfeiture on account of a breach of a covenant which does not concern the non-payment of rent, then there will be a requirement for the landlord to serve notice under Section 146 of the 1925 Law of Property Act. This is sometimes known as a Section 146 LPA notice. The Law of Property Act says the following in relation to Section 146. They say, quote, "A right of re-entry or forfeiture under any provision or stipulation in a lease for a breach of any covenant or condition in the lease shall not be enforceable by action or otherwise unless the lessor serves the lessee a notice specifying the particular breach complained of, and if the breach is capable of remedy, requiring the lessee to remedy the breach, and in any case requiring the lessee to pay compensation in money for the breach." So this actually allows for the existence of a remedy away from forfeiture itself. So if you have a breach of a covenant that is not the non-payment of rent, that is a separate issue. But when it comes to any other kind of breach of covenant, you should send them a Section 146 notice, and then that notice shall specify the breach in question, specify if there is any remedy for that breach that could essentially save the tenancy agreement, and then in any case, in any situation, there would be a requirement for the lessee to pay some kind of compensation in money for said breach. The landlord will often be required to allow time for the notice to be complied with, if possible. So if there is a compliance requirement here that essentially allows for the tenant to do and perform some action that will essentially save the leasehold agreement and deal with the covenant breach nice and easily, then there should be time allowed for this notice to be complied with. Bear in mind, again, the process of getting a Section 146 notice or the process of getting a court order under the Protection from Eviction Act and actually getting an eviction to take place is all a process that a landlord is likely not going to want to have to deal with. So if there is a breach of a covenant for which there is a potential remedy, they're probably just going to send a letter to the tenant and say, look, please just deal with this remedy. We'll give you time to comply with this notice. I don't want to evict you. Please, let's just get and deal with this problem. Because obviously it's a headache for everybody involved for there to be an eviction. It's only in the extreme circumstances that they will go with a proper eviction process. If there is available remedy, then this will usually amount to 3 months' notice. So 3 months' time, at least, allowed for that notice to be complied with. Quite a significant amount. And is also, in fact, been confirmed in the case of Expert Closing and Hillergate House Limited from 1986. If there is not a remedy, then you may have a compliance requirement of 14 days, as per Scaler House District versus Forbes from 1974. So given all these facts, you might think that this is seemingly particularly strong in terms of the kind of power that a landlord may have over a tenant, and in some circumstances it is. However, there is relief from forfeiture. There is the ability for there to be relief from forfeiture, which essentially protects a tenant against the strongest claims of forfeiture, or at least if there is the requirement of a breach of a covenant, or if there is a breach of a covenant, let's say, that there could be relief by way of remedying that situation, which does not necessarily result in a forfeiture agreement. So these are essentially the steps that a tenant is able to take in order to remedy the forfeiture and therefore allow them to stay inside the property. For cases that involve the non-payment of rent, relief from forfeiture is actually quite simple. It is just pay your rent, pay the arrears that you are in, and if this is done before the court order is executed, then the relief will be successful, and there is no recourse for the landlord to kick you out and for there to be an eviction. If not, applications may be entertained up to 6 months after the issuance of a court order, which could then also give you relief from forfeiture. When it comes to breaches of covenants that do not involve the non-payment of rent, then the relief can be issued up to the repossession of the property itself. It will generally be up to the discretion of the court as to whether or not the relief from forfeiture has been successful. Generally speaking, if there is a compliance with good faith and a compliance in good faith in any of these cases, often it will be the case that relief be successful. Obviously, unless we're talking about the quite severe breaches of covenants or the severe non-payment of rent to which people are in ridiculous amounts of arrears. But if there is generally the charitable the charitable and good faith compliance with the court order or with the threat of a court order with a Section 146 notice, then there will often be a successful relief from forfeiture. But obviously these things are dependent on a case by case basis.